Hello students of Grade 10, my name is Ms. Nisha Bamfield and welcome to another session of Office Administration. In today's lesson, we'll be looking at retention, the use of documents as it relates to its legal stipulations. Our objectives are to define legal stipulations and to describe the main legal stipulations governing access to and the use of retention documents. What is legal stipulation? Legal stipulations, an agreement usually on a procedural matter between the attorneys of two sides in a legal action. Some stipulations are oral, but the courts often require that the stipulation be put in writing, signed, and filed with the court. This is referenced from the 1981 to 2005 Garnold N. Hill and Kathleen T. Hill, all rights reserved. What are they used for? They are an agreement between attorneys that concerns business before a court and is designed to simplify or shorten litigation and save costs. During a civil lawsuit, criminal proceedings, or any other type of litigation, the opposing attorneys may come to an agreement about certain facts and issues. Such an agreement is called a stipulation. Courts look with favor on stipulations because they save time and simplify the matters that must be resolved. Stipulations may cover a variety of matters. Parties are permitted to make stipulations to dismiss or to discontinue an action, to prescribe the issues to be tried, or to admit, exclude, or withdraw evidence. In today's lesson, we'll be focused on the first 4 of 7 legal stipulations. These are rights of access, infringement to copyright, limitations on the rights of access, and defamation. Regulations pertaining to rights of access. The right of access plays a central role in the General Data Protection Regulation, GDPR. On one hand, because only the right of access allows the data subject to exercise further rights, such as rectification and erasure. On the other hand, because an omitted or incomplete disclosure is subject to fines. The answer to a right of access request includes 2 stages. First, the controller must check whether any personal data of the person seeking information is being processed at all. In any case, one must report a positive or negative result. If the answer should be positive, the second stage involves a whole range of information. The rights of access includes information about the processing purposes. 2. The categories of personal data processed. 3. The recipients or categories of recipients. 4. The planned duration of stage or criteria for their definition. 5. The right to object. 6. Any existence of an automated decision-taking process, including profiling with meaningful information about the logic involved as well as the implications and intended effects of such procedures. 7. Information about the rights of the data subject, such as rectification, erasure, or restriction of processing. Information about the origin of the data if these were not collected from the data subject himself, and instructions on the right to lodge a complaint with the authorities. Last but not least, if personal data is transmitted to a third party or third country without adequate level of protection, data subjects must be informed of all appropriate safeguards which would have been taken. Information can be provided to the data subject in writing, electronically, or verbally as per Act 12(1), Sentence 2 and 3 of the GDPR, depending on the circumstance. According to Act 12(3), GDPR information must be provided without undue delay, but at least within 1 month. Only in reasoned cases may this 1-month deadline be exceptionally exceeded. As a rule, the information has to be provided free of charge. If, in addition, further copies are requested, one can request a reasonable payment which reflects administrative costs. The controller is also allowed to refuse a data subject's request to right of access if it is unjustified or excessive. The controller additionally has the right, if he is processing a large volume of information about the data subject, that he or she specify their requests within the right of access regarding specific data processing or kind of information. For further details on Article 12, please see the following as suggested. Let us now look at the regulations pertaining to limitations on the right of access. The grounds on which is permissible to limit the right of everyone to receive and impart information, including any information led by public bodies, are listed in Article 19 of the Universal Declaration of Human Rights, Article 19 of the International Covenant on Civil and Political Rights, Article 10 of the European Convention on Human Rights. A more detailed regulation of matters relating to limitations of access to information is contained in the Council of Europe Convention on Access to Official Documents. Similarly, Regulation EC 1049/2001 applies on the right of access to official documents held by institutions of the European Union. Applicable to the limitation of access to the information regarding the protection of personal data are Convention number 108 of the Council of Europe for the protection of individuals with regard to automatic processing of personal data, Directive 95/46/EC on the protection of individuals with regard to the processing of personal data and on the free movement of such data, and Regulation EC number 45/2001 of the European Parliament and the Council of 18th December 2000 on the protection of individuals with regard to the processing of personal data by institutions and bodies and on the free movement of such data. Protection of personal data is a fundamental right recognized by the Council of Europe and the European Union. The balance between the two rights is subject to the case law of the Court of Justice of the European Union as well as to the European Court of Human Rights case law. Requirements regarding limitations. Contents of the requirements regarding limitations on access to information in accordance with the international standards are as follows. According to Article 10, Paragraph 2 of the European Convention on Human Rights, limitations on the right of everyone to receive and impart information may be applied only if three conditions are simultaneously present. Restrictions must be: 1. Expressly provided by law. 2. Proportionate to the aim of protecting one of these interests. 3. Proportionate to the aim of protecting more of these interests. 4. Necessary in a democratic society. These conditions are applicable to the limitations and are termed triple tests, the application of which in the specific cases is detailed in the European Court of Human Rights case law. The regulation of limitations is developed regarding the rights of access to official documents in the Convention on Access to Official Documents, which is the most extensive in this respect. International documents, according to Article 3, Paragraph 1 of the Convention. Each party may limit the right of access to official documents. Limitations should be set down precisely in law, be necessary in a democratic society, and be proportionate to the aim of protecting all. The limitations also focuses on tests for harm and overriding public interest. Means of introduction. Limitations on access to information under the Belgian legislation. Applicableness of the balance of interest to individual restriction. Degree of applicableness of the balance of interest to the individual restrictions. The applicableness of the harm test and deadlines for the different limitations. We will now turn our focus to the regulations pertaining to infringement to copyright. What is considered copyright infringement? Copyright infringement is the use or production of copyright-protected material without the permission of the copyright holder. Copyright infringement means that the rights afforded to the copyright holder, such as the exclusive use of a work for a set period of time, are being breached by a third party. Copyright law affects one's right and ability to use another's work, including writings, drawings, photographs, paintings, software codes, or business plans. The purpose of copyright law is to promote the creation of works by giving authors exclusive property rights. Copyright law is intended to encourage the dissemination of these works, blustering and competitive marketplace. The following types of works are allowed protection under the copyright law. These works are literary, music and dramatic, pantomimes and choreographic works, pictorial, graphic and sculptural, motion pictures and other audiovisual, sound recordings, compilations. The primary objective of copyright is to induce and reward authors through the provision of property rights, to create new works and to make these works available to the public to enjoy. The theory is that by granting certain exclusive rights to creators, which allow them to protect their creative works against theft, they receive the benefit of economic rewards, and the public receives the benefit of the creative works that might not otherwise be created or disseminated. The question is, how can you protect your work? Notably, A copyright symbol, such as a scene, is no longer required to receive copyright protection. It is wise for authors and businesses to include the symbol so that an infringer cannot claim to be unaware of the copyright. Publication or registration in the Copyright Office is not required to secure copyright protection for works created after January 1st, 1978. Works are copyrighted at the moment they are fixed in a tangible form. What if your works are infringed? If a copyrighted and registered work have been infringed, file a claim for copyright infringement. However, this must be done within 3 years after discovering the infringing act, because that is the legal deadline for a copyright infringement claim. Each time a copyrighted work is infringed upon, the owner has 3 years to file a lawsuit, which means each time the infringer uses your work or commits an act of infringement, a new 3-year limitations period commences. In some instances, you can file a lawsuit more than 3 years after the infringement occurs or the discovery of the infringement. But you would only be entitled to the damages for the 3 years preceding the date you file the suit and not for any infringing activity that occurred prior to then. Let us turn our attention to the regulations pertaining to defamation. The law protects people from any types of harm, including harm to one's good name and character. Many nations' legal system affords people the right to sue when false and defamatory statements have harmed their reputations. Elements of defamation. Defamation is a communication that tends to harm the reputation of another, to lower his estimation in the community, or deter third parties from associating with him. A statement is defamatory if it has a negative impact on someone's reputation among a substantial number of people in the community, even if the number of impacted people is not a majority of the community. Since these rules offer only general guidance, the determination of whether a negative statement rises to the level of defamation must be determined on the case-by-case basis. Every defamation claim must meet the following 4 elements. A false statement concerning another. B, the statement must be defamatory. C, a publication to a third party. And D, harm to the plaintiff's reputation. For a statement to be considered defamation, it must be about the plaintiff, even if the statement does not mention him or her by name. It can be actionable on grounds of defamation if a reasonable person would understand the communication as referring to the plaintiff. Defamation defenses. A fundamental rule of defamation law is that truth is an absolute defense. If the alleged claim is true, then the publisher cannot be sued for libel or slander. Other important defenses to claims of defamation are as follows. The law recognizes certain forums as especially in need of protection from litigation to foster free and open discussion among the participants. Legislators and politicians debating public policy in legislative proceedings have an absolute privilege which protects them from defamation claims. Likewise, to protect the integrity and independence of the court system, statements made during judicial proceedings are considered privileged and cannot be targeted for defamation claims. Finally, communications between married couples are not subject to defamation claims. This is in line with the well-established principle of privileging conversations between spouses. Now that we've come to the end of our first lesson covering the retention and use of documents under the legal stipulation guidelines, I want to thank you for your apt attention. My name is Ms. Neja Bamfield, and I enjoyed this time with you today.